we're going to look at deportation, immigration deportation. I came across a headline in the Daily Mail the other day, and it kind of stuck out to me. It said, Turkish criminal is allowed to stay in the UK after judge rules his gang membership shows he is socially and culturally integrated in Britain. The article, the mini headline said, TOLGA, BINBUGA convicted of burglary, robbery, assault and criminal damage. The Turkish national was allowed to stay in the UK because of his gang membership. Judge ruled his gang ties showed he was socially and culturally integrated in the UK. And I thought, what? Allowed to stay in the UK because he's a member of a gang? Am I reading this correctly? The Immigration Act 2014 brought in the hostile immigration policy. Well, part of it. It was part of the hostile immigration policy introduced by Theresa May when she was acting as the Home Secretary. And then I then thought, well, the immigration rules can't be that tough if a known criminal, a foreign criminal, is allowed to stay in the UK because he's a member of a gang. That's completely balmy, crazy. So how could this be? How could a foreign criminal convicted of a string of offences be allowed to stay in the UK because he was a member of a gang? Right, I'm going to discuss the case of BINBUGA in more detail and explain how the deportation laws operated in relation to his case and why that headline was misleading. All right, let's look into the background and history of TOLGA BINBUGA. Now, he arrived in the United Kingdom in 1999 when he was aged 9 years old. His family were granted indefinite leave to remain in 2004. He arrived in the UK with his mum, his dad, his siblings from Turkey. Now, in the same 2004, when they got indefinite leave to remain, he received his first conviction. Well, that wasn't actually a conviction. It was a reprimand for shoplifting. He was 13 at the time. At the age of 16, he was convicted for robbery. At the age of 18, he received a caution for possession of cannabis, and a few months later, still at the age of 18, he was convicted of criminal damage. Now, he didn't offend again for 5 more years, but in August 2013, he was convicted of assault occasioning bodily harm and was sentenced to 4 months imprisonment. This was suspended for 18 months. About 6 months later, in March 2014, he was convicted again, but this time of burglary and theft, and of failing to comply with the requirements of the suspended sentence he had received a few months earlier. He was sentenced 9 months imprisonment for the burglary, and he was given 3 months imprisonment for the breaching of his suspended sentence, which was activated due to his the fact he had committed the burglary. In 2015, the Home Office said, well, that's enough now. We are going to issue a deportation order against you. And TOLGA appealed against that. In a nutshell, deportation relates to foreign criminals. And a foreign criminal is a person who is not a British citizen, who has been convicted of an offence and has either A, been sentenced to a period of imprisonment for at least 12 months, B, has been convicted of an offence that has caused serious harm, or C, is a persistent offender. In this case, in TOLGA's case, the Home Office decided to issue a deportation decision against him because they had decided he was a persistent offender. They took the view that his criminality and lack of evidence of positive contributions had failed to demonstrate that he was socially and culturally integrated in the UK. Even though he had never resided in Turkey as an adult, he had spent his formative years there. He retained familiarity with Turkish customs and language and had family remaining in Turkey. The Home Office decided that, listen, his criminality outweighed any family considerations he had, and that the relationship he had with his friends, his family, his siblings did not go beyond normal family ties or friendships. In the Home Office refusal letter, they said, look, he could carry on any relationships he has through the modern means of communication, which would be social media, the internet, emails, things like that, FaceTime. Now, there are exceptions to deportation if you have committed a crime or you've been convicted of a crime, I should say, in which the term of imprisonment is less than 4 years. If you've been sentenced to a term of imprisonment for less than 4 years, then there are two exceptions you can rely on. The first is that you're lawfully resident in the United Kingdom for most of your life. You're socially and culturally integrated in the United Kingdom, and there would be very significant obstacles for your integration back into the country in which it is proposed that the Home Office return you. So the first exception has three parts. The second exception is if you have a genuine and subsisting relationship with a qualifying partner, or a genuine and subsisting relationship with a qualifying child. A qualifying partner or a qualifying child would be somebody who had British citizenship or had no restrictions on their time limit to stay in the United Kingdom. So somebody who, for example, had indefinite leave to remain. In TOLGA's case, he was relying on the first exception, and the first exception, as I've said before, has three ambits to it. The first one is that he has been lawfully resident in the UK most of his life. The second one is that he's socially and culturally integrated in the United Kingdom. And the third one is that there will be very significant obstacles for his reintegration back into Turkey if he was sent there. Now, unfortunately, the judge who allowed TOLGA BINBUGA's appeal did say this: gang culture is sadly a part of life for many young people in this country, and the fact that the appellant appears to have involved himself in that culture is, in my judgment, an example of his integration into life in the UK. Now, what the Daily Mail doesn't tell you in their bold headlines is that that decision was actually made in 2016. In 2017, it was overturned by the upper tribunal, and that decision was affirmed by the Court of Appeal in 2019, this year in March, 19th of March to be exact. Now, this is what the Court of Appeal had to say in relation to TOLGA BINBUGA's membership of a gang and whether or not that made him or demonstrated that he was socially and culturally integrated in the UK. Membership of a pro-criminal gang tells against rather than for social integration. In this context, social integration refers to the extent to which a foreign criminal has been incorporated within the lawful structure of the UK. This includes various incidents of society such as clubs, societies, workplaces or places of study, but not association with pro-criminal peers. Similarly, cultural integration refers to the acceptance and assumption by the foreign criminal of the culture of the UK, its core values, ideas, customs and social behaviour. This includes acceptance of the principle of the rule of law. Membership of a pro-criminal gang shows a lack of such acceptance. It demonstrates disdain for the rule of law and indeed undermines it. So essentially what the Court of Appeal are saying is, listen, you can't be a member of a gang and say that you are socially and culturally integrated in the United Kingdom. So if you're a foreign criminal, you've been convicted of an offence, it's going to be almost impossible for you to rely on one of the exceptions to deportation, which is that you're socially and culturally integrated in the United Kingdom, because the law is now saying, the case law is now saying that if you are in that gang, that tells against your social integration and cultural integration rather than for it. So even if you've been in the UK lawfully for most of your life, and even if there are significant obstacles for your return to your country of origin or the country in which they seek to propose to return you, they will always argue you're a member of a gang, so you're not socially and culturally integrated. The Daily Mail's article is dated the 9th of April 2019, so rather than the Daily Mail to report what the Court of Appeal had said and use that as the headline, it chose rather to infuriate its readers and create a sense of anger by misleading the public into thinking that the decision of the judge was recently made. And so you come away with a false impression that, one, the laws in the UK must be terribly easy and soft towards foreign criminals. And two, if you are a foreign national in the UK, you'll read that and think, oh, what, really? So that guy was allowed to stay because he's a member of a gang. I might as well join a gang right now. It's totally misleading. The lesson to learn here is this. In the UK at present, there exists a hostile immigration policy. And that policy is extremely harsh towards foreign nationals who commit crimes. If you're a member of a gang, if the police have information and intelligence that you're a member of a gang and you do commit a crime, it's going to make it extremely difficult for you to argue on appeal that you are socially and culturally integrated in the United Kingdom. And that's what really the case of BINBUGA versus the Secretary of State for the Home Department actually says. Despite the misleading headlines from the Daily Mail, that, as I say, is simply to create an impression, in my opinion, that the immigration laws are too lax, too loose, when in fact they are extremely harsh, particularly if you are a foreign national. My name is EWCA. I am signing out. I'll be back again to talk about visas and common mistakes I have noticed in practice that people tend to make over and over again in visa applications.